It is Thursday, July 18th, and it is now 1:32.
Regular members, too.
Preliminary matters to come before our board today. The agenda, is there any additions or deletions to our agenda today?
Staff has none, Mr. Chairman.
No board? Okay, thank you. Is there any early public comment that would like to have? If you wish to speak before the board, please come forward. Please state your name and possibly your address. And
my name is David Hunter, and my address is 3702 Eagle Drive over in Central Beach. And I'd like to thank all the board members for their vigorous work in helping to preserve and maintain the beauty and integrity of the city of Vero Beach, and also to thank the city council. I was at their meeting a few days ago and realized how extensively they have to go into all of these complex issues. So I realize that all of you are working for the betterment of our city, and I appreciate it. It's not a terribly rewarding experience sometimes with all the difficulties that you have to deal with, but I appreciate it, and I think a lot of the other citizens do. I'm here to, first of all, report on the status of the Eagle Drive Delight debacle that we experienced on my street several months ago with continuous vacation rentals being done, and to say that happily that situation has now been resolved. The $50 fine apparently gave enough impetus to the violators to have them cease and desist from further action. They've now moved back into the house. The owner, in fact, came up to me and approached me and said that she was sorry that she had done that and that she wanted to work with us to help clean up the neighborhood, which I found rewarding and hopefully sincere. The situation with vacation rentals, though, does not just exist on Eagle Drive. It is a problem that is spreading across all of our residential areas. And that's why I wanted to take a couple of moments and give you an update on the situation, hopefully with the idea that you can address this within the current committee and at the city council level.
David, may I ask you, would you like to bring this up during this particular presentation and now as opposed to later on, because we will be addressing this under public hearings? So would that
you do have it. You have it under public hearings
for today.
Okay,
no, excuse me, Mr. Chairman. We're not dealing with short-term rentals. This is a different issue.
Forgive me.
Yes.
Okay, stay.
Okay, yeah, because I think there is the issue of the boarding houses, which I know you've been addressing and trying to modify the wording on, and that's a relatively similar situation, but it's not exactly the same within the code, but very close. Vacation rentals have been expanding in Central Beach and all across Riamar, and I believe on the mainland as well. There's a vacation rental by owner site, vrbo.com, which just for the Central Beach area listed over 270 properties that are being offered, many of them by the night or by the week. And a lot of the owners, I've checked a few of these, the owners are out-of-state owners. So they're renting in violation of city code if they are indeed in the residential areas of the city. I want to discuss the city code issue in a moment, but the first issue also is we have a problem within the city government, it seems to me, at the council level of at least one member who does not seem to adhere to our city code. This individual, the spouse of the Vice Mayor Tracy Carroll, has been renting out on a short-term basis since 2010, several properties. In 2012, they were cited, but not financially, for a Sea Grape 906 Sea Grape Lane for renting out on a short-term basis. Vacation rentals is the term. In addition, at the same time, they were renting out a property 530 Camellia Lane, which is in Central Beach. And the property is listed on internet sites under flipkey.com and lists the guest reviews. And some of those guest reviews includes that we enjoyed our stay for Christmas in December 2011 for 9 days, and the owner, John Carroll, was wonderful. All 14 of us staying at this house. I mention this because if the city council members are not themselves abiding by the code of the city, this represents a question of ethics and a question of whether they should be reprimanded for violating the code while involved in the city government. The violator himself, John Carroll, was at the time of these violations serving on the Code Enforcement Board of the city. And I would assume that he was obligated to swear to the upholding of the city code, and if he did not agree with the city code, that he would remove himself from the board, the Code Enforcement Board, and attempt to modify the code before breaking the code. So it strikes me as a serious depredation of our government when officials are breaking the law themselves. I speak as a former government official, that I know that this would never happen or should never happen. We contacted in complaint regarding the Eagle Drive property the council member Pilar Turner by writing, and in response she replied that the City of Vero Beach ordinance regarding short-term rentals is weak and does not provide sufficient penalties to include compliance. This again indicates that we have a problem and that some members of the City Council feel that we have a problem but maybe are not addressing it adequately, especially if we've got hundreds of properties being rented out in the city in violation. I would mention to the board that a vacation rental is not a rental in the category of a tenant-landlord agreement where you are renting out by the month or by 6 months or a year. A vacation rental is a public dwelling establishment, and it is under the same category of law as a hotel or motel. And the state of Florida, under its Florida statutes, defines public lodging establishment classifications, including hotel, motel, vacation rental. And vacation rental is defined as a transient public lodging establishment. And under the state of Florida, if you're going to run a transient public lodging establishment, you must have a state of Florida vacation rental dwelling license, which in the license itself states that you are running a transient establishment. That's under the vacation license code. I'm sorry, HR 7028. HR 7028. And that's issued by the Florida Department of Business and Professional Regulation. So to run a vacation rental, you have to have a license from the state of Florida, and you're supposed to be paying taxes. And very possibly you need to have a county and a city business license. I know the hotels have to have those. Now, speaking of vacation rentals, I know in the county commission there was some discussion about how vacation rentals were beneficial to the county. I strongly disagree with that conclusion. Vacation rentals are detrimental in many ways. Obviously, to the guests, the tenants that not the tenants, the owners of properties that live next door, it's disruptive. These people come in for a week or less. They're coming in, unloading their suitcases. They're having parties. They're parking on the lawn. There's a nuisance factor at a minimum, and a security factor if you calculate that you don't know who these people are that are coming and going. It destroys the integrity of the neighborhood because we don't have permanent residents living there. We have transients coming and going. But it also damages the existing hotel and motel businesses. It's taking money out of the pockets of our hotel and motel industry. I went down on Ocean Drive, and I've talked to a few people down there in the hotel business. They are cutting their rates. The Holiday Inn Oceanfront now has rates for the summer of $100 a night because they're trying to keep full. A lot of the other hotels are cutting their rates to keep full. These are people who are playing by the rules, who are honoring our city code and paying their taxes and having property managers and safety regulations for the guests that are involved there. That is not the case with these vacation rentals that are running Motel 6s across the street from residential property. So it's not a beneficial industry, and it's being done illegally. And it's illegal by the state of Florida if it doesn't have a license. And if it has a license, then it's illegal in the city of Vero Beach because it's zoned transient, and we only allow transient rentals in C1 and C1A. Now, as far as the law not being adequate to address this, I think the law is adequate. I think that as long as we make the clear assumption that when we wrote that law, that we said transient dwellings and temporary lodging is only allowed in C1 and C1A, along with hotels and motels, that if we had intended there to be transient dwellings in other areas of zoning, we would have specifically written into the city code that those other zoned areas, such as R1, would also be allowed for transient dwelling. But it was not. It was only written into the commercial code. So I think that if we take a proactive approach, and if the board here makes efforts not to modify the code, because we know the state of Florida doesn't want you to modify the code on vacation rental, but to clarify the code, to say very clearly that transit rental is a vacation home rental, and that under transit rental it cross-references to our city code. We're not changing our code. We're sticking with our code, but we're just insisting that the code be enforced and that the code be clarified so that people who are violating the code will see more clearly that they're violating it. The last thing I'll mention is that in terms of penalties, Ms. Pilar Turner was correct that the penalties do not appear to be adequate to discourage the conduct, although they did in this one case with my neighbor. The penalties could very well be increased. There's no reason why the penalty for first-term violation could not be raised to $250 and the second penalty raised to $500 and so forth. There is nothing except the vote of the City Council to preclude raising the penalties. And I do not believe that raising a penalty for a violation would fall under this restricted category of this Senate on vacation home rentals. I don't think that modifying your penalty to adjust for inflation would be improper. We have been adjusting penalties for inflation in other categories, so I don't see why there would be any reason to prevent that in this case. So in closing, I ask you as a zoning and planning board to consider vacation rentals as an approaching crisis situation for the city, and one that needs to be addressed immediately. The fact that Ms. Carroll is legally challenging her citation, her $50 fine, is troubling, and I think it should trouble all citizens of this city to know that we may end up losing our zoning altogether. If that is successfully overturned, and we don't have any zoning for vacation rentals, then you can have vacation rentals popping up in every corner of our city, including all the residential areas next door to schools, anywhere you look at it. Thank you very much for your time.
Thank you. Anybody have any questions of David? Thank you.
Yep.
Is there anybody else in the public who would like to speak before the board? Seeing no additional, we'll move forward then. Today, I would like to put into the minutes that we have Dawn and both Robin are excused, have excused absence, if you would note that, Jerry. And the next thing, we'd like to get approval of our minutes from the regular workshop meeting of June 6th.
So moved.
Do I have a second?
Second.
Any discussion on that? Then I'm looking for a vote on it. All in favor, say aye.
Aye.
Opposed? None. Now we'll do the regular meeting of June 20th, 2013. Looking for an approval of those minutes.
So moved.
Second.
Any discussion? Looking for a vote.
So, okay.
All in favor?
Aye.
Unanimous. The next item we have is the public hearings legislative, and I should read those. Okay. This is an ordinance of the City of Vero Beach, Florida, amending the code of the City of Vero Beach, Chapter 62, Non-Residential Districts, Article 3, by creating Section 62.36 to provide for a planned development as a conditional use of the C1A and C1 commercial zoning districts, creating an Article X1V, planned developments, providing for minimum eligibility requirements, providing for conditional use requirements and minimum performance and development standards, providing for waivers from development standards that demonstrate and promote a public benefit, providing for conflict and severability, providing for an effective date.
Oh.
Tim, do you want to
Yes,
pick it up?
I'll handle it. There's nobody else here. Here I am. The ordinance you see before you for hearing basically is the same ordinance you saw at the workshop. I'm just going to briefly go over some of the aspects of it. As you recall, the genesis of this ordinance comes out of the vision plan, the City of Vero Beach Comprehensive Plan, as well as our evaluation and appraisal report that is calling for incentives to promote infill development, particularly mixed-use development, which gets people out of their cars. It creates a more of a creative and efficient use of land than we do have in the existing lands development patterns that we have in the city. Unfortunately, our current ordinance lacks the flexibility to do this without going through detailed design work, which we did for the overlay district in Cardinal Drive and Ocean Drive. We would have to go through a variance process, and to do that would probably be legally suspect and then also be very time-consuming to do that. So this is a much more flexible approach to do. We worked with the Mr. Keith Kite and his group. He had Kimley Horn working with us. This goes back 3 years when we started this, and this has been refined to the ordinance which you have now. Basically, and I'm just going to briefly go through it. This adds the ordinance will be adding a planned development as a conditional use in the C1, C1A zoning districts. It does exclude this type of overlay, this kind of planned development in the overlay district in the Cardinal Drive because we already have regulations there. The minimum requirements for this type of development, at least 50,000 acres. They generally have to be contiguous. However, we do allow a right-of-way. 50,000 acres, 50,000 square feet. Take in the city by the time we're done. Way beyond the city. We do allow.
1 acre.
Pardon?
1 acre. Is that right? Or are we talking?
1 acre.
Is it 10 acres? I don't remember.
50,000 square feet, which is a little
less than
it's a little more than an acre.
Yeah.
Okay. Normally, we have lots that have to be contiguous. This does allow separation of parcels by no more than 70 feet of right-of-way. This allows, which gives you more flexibility than our current code does. They're going to have direct access to an arterial or major collector, so they just can't be located anywhere. And they're all development, all parcels within the planned development have to be under one development order. We have an application review and approval process, and basically that follows our current development review process. So all these type of projects will be coming before you all since it requires your approval on any of the waivers and the other aspects of it. It is a conditional use, so it does follow our criteria for conditional use in addition to other criteria that we have in here. Our minimum performance standards, which we outlined in there, a lot of them are linked to.
Excuse me, David. Thank you.
A lot of them are linked to creating more pedestrian-oriented linkages, outdoor use of space. We also have prohibitions to driving through drive-up facilities. We've added restaurants to that because we didn't want to have those kind of restaurants in there. The only thing we have allowed, we still have financial in there. That's the only one we allow the kind of drive-up facilities.
Tim, a question?
Yes, go ahead.
Banking, drive-through banking, is that going to be
That'd
permitted?
still be in there, and we've let that in there because of the situation. It was tailored to get the Hampton Inn project moving forward, and they do have a drive-in facility. I mean, we could put in a vesting clause for existing to do that, but we didn't talk about that. So, that's something.
The only reason I'm questioning that, Tim, is I'm looking at our land use map, and I'm looking at all the commercial, the C, the zoning, which is marked in red. And I'm looking at one on the South Barrier Island, and I wondered just how appropriate that is to allow a drive-in banking use there. It seems to be...
Well, if it's... I mean, it would be allowed under the current... If it's allowed under the current ordinance. If it's C1A, I believe it's limited. C1A allows drive-in banks. I'd have to get the ordinance to take a look at it. So that...
Okay.
Remember,
That
the
would be
underlying zoning, unless it supersedes it, is going to be in place. So, just a second. Let me try to answer.
Sure, thank you. Yeah.
I think they already have the ability to do that. I'm not sure.
No, it just excludes restaurants. But remember, any of these projects will have to be conditional use review. So they're going to have to be innovative, flexible type projects. So you're going to have the developers, when they're going to come in and want to tailor it to fit the particular area, you're going to have to look at contextual things. That's all in both the conditional use and the criteria.
Okay.
So I think without limiting the flexibility here, I think that would come up in a case-by-case analysis. All right?
Thank you.
Tim, this 1 acre minimum is bothering me. It seems awful small. Where did we come up with that number?
Well, that's a threshold that we basically picked, that it was big enough that you could do something on it. But, I mean, what type of threshold?
Aren't most single buildings on an acre? Single commercial building?
Not all of them, not in some of the districts. I mean, obviously, the bigger the acreage you have, the more flexibility you have in design to put it together.
How big would the Hampton Inn property be, for example?
Just a second.
Sir, can you come up to the
Come up.
microphone,
Come up,
please, and state your name?
Keith Kite Properties, developer of the Hampton Inn project. The overall parcels, 5 parcels making up the Hampton Inn parcel, which are contiguous, is 2.33 acres. The overall planned development of the Miracle Mile overlay or use that we're projecting here is just over 3 acres. And commercial buildings could be as low as quarter-acre tracts, such as the Starbucks in front of the Publix or Einstein Bagels. Taco Bell's run about a half acre. So I don't know the threshold.
Well,
that we want to
I
get
would
to.
say I think Mr. Ucher's got a valid point here. Of maybe at least increasing it, just because we're talking about a mixed-use type development, and when we're talking about these standalone establishments. So I think at least going to 100,000 square feet would be reasonable.
I was going to ask your opinion from a developer standpoint.
Yeah, I would think that probably 100 may be pushing, but a 2-acre tract would probably require a PD just to get that assembled.
It
with all
is a
the parcels.
conditional situation, though, so we have the right to look at it. Is that correct?
You may not you want to limit it that big, so you may want to test these and see how they go, flexibility wise. But that's
Right. I mean, I think it's a valid point on the size of it, but we do have some flexibility on this, and to see how it goes. I mean, I don't know if you can get an innovative. You may on some very small projects on only 50,000 square feet.
Well, the danger is you're trying,
to put too much on a
10
piece of
pounds
property.
of poop in a 5-pound bag.
But you may have an alley situation or something like that, which would allow you a little more, the possibility to do it within the regulations.
Well, this allows you to, obviously be across right away and all that. So
Right.
you do have more of an opportunity to combine parcels as part of the development
Right.
to be considered in that. I mean, I don't think I have a problem if you wanted to double the size. Obviously, it would fit their project easily. Or go to something in between just to see how this works. I mean, again, I keep saying when we do these kind of things, a lot of it is fine-tuning. As we go along, we learn by our experience. So I'll defer to you all. I mean, you've heard the arguments on.
It just seems small to me. I suppose we could start at 7,500,
75,000.
75,000.
Well, are we limiting what someone wants to do that could be reasonable?
Yes, that's my
Yeah.
point.
Well, that's it. And we don't have experience in that. It's just that, other than, I'm looking at a mixed-use project, and usually you're going to have a little more, but you're right. You may be limiting somebody that's got a nice, innovative project that is smaller than that. So I think basically if it's a minimum 50,000, I believe you're probably going to have people coming in with more than that. But to get the flexibility and the things they'll want, they're going to want more property in there to give them that flexibility. So probably from practical purposes, it really doesn't matter. We wouldn't want it too low, but at 50,000, it's at least an acre. That gives you some. So we could stick with this and see how it works. All right? Okay.
I agree.
Tim, I had a question. I'm sorry I didn't get to you prior to the meeting, but it's over on page 2 under no drive-in, drive-through.
Right.
And you've said note restaurants have been added to the ordinance. You meant added as a prohibition. Is that correct?
Note have been added to the, exactly right. If you read it, we've added it in
Okay.
that section.
And the Hampton Inn, it's not contemplating
No,
a
no,
restaurant?
it's a drive-in through. We want
Only
restaurants.
drive-through
But we
restaurants.
don't want drive-through, those type of restaurants.
Okay, good.
Okay, and the maximum density provisions will be on the total land area of the project. So that allows them to concentrate on one or more parcels as long as the overall development meets the code. And probably the major thing with the ordinance is the plan development waiver section, where we have incentives to encourage projects that are innovative, creative, and utilize planning, design, and architectural concepts that will benefit the city and the public. You have the authority to grant waivers from specific development standards, which we've outlined there, but they have to meet the criteria in there, and the public benefit has to be served. That's probably the major thing in there. You just can't be giving away the store. They've got to be some direct public benefit, and remember, these are all quasi-judicial type things, so it's substantial competent evidence to do this. So, I've also gone through the analysis of it. Sometimes it's self-serving since we help write the ordinance and we're reviewing our ordinance, but I have to show how it meets the code. Our review of this shows that it's consistent with the comprehensive plan and also internally consistent with the land development regulations themselves. Unless you have some specific questions, I'm not going to read those, but those are all in your report. So our recommendation is that you would go forward and recommend approval of this to the City Council with any revisions you deemed appropriate to make during this. So unless you have some questions of me, I suggest we open the hearing.
I do have a question.
That's all right.
Public hearing first?
Just a clarification here. On the Architectural Review Commission, that's in the application review
Yes.
and approval process, it's not going to be seen by them prior to?
They can't. The architectural review, until they get some design criteria in, we can't. They don't have the authority to do the reviews. The only reviews they can do now is in the overlay district. All right, and we're still working with them. When I say we're the staff, we're still working with them to come up with design review criteria, but they have to still go through to get it memorialized or enacted in an ordinance. So we're a long way from that. I left the provisions in there. Once that happens, they'll automatically kick in.
I was wondering whether this would be premature to even include it here, but
I put it in there because I don't want to have to come back to amend the
Okay.
ordinance, and that was
All
my
right.
way of handling that. All right?
Okay. All right.
Okay. I just want to say the draft ordinance itself, before we open this up, is the attorney. There's a couple minor edits in it, and I've caught a couple. And plus, Wayne, the city attorney, will be going over that. So we'll probably make
Wayne,
some
have
other.
you done a review yet, or you're still waiting? Okay.
No, but there'll be some
Till we get done,
wordsmithing.
okay.
But anything substantive, we certainly would make you aware of that. So.
I'd now like to open it to the public. If you'd like to have any comments on this, please come forward at this time. Seeing none, we'll close the public comment on it. It's open for the board for discussion. How many times have we been through this somewhat?
I think we had a whole at our workshop. We went through
At least-
it
that's a while
fairly
back.
in detail. Yes, and as I said, there hadn't been a lot of really many changes other than editing, and I added the restaurant, so everything else has been fairly the same that you saw it the first time around.
So we've seen this a number, I think, many times. It's pretty much now, it's what we've asked for and what we've reviewed upon. Is there any discussion at all?
of course.
Okay. Go ahead. Come on.
Okay, on the purpose one, number 5,
Wait.
I'm curious about the balanced transportation system. Is there provision for on and off-site parking, covered parking, that kind of stuff?
Well, I think that's going to be what you're going to look at to see what public benefits are done and how the project's done. This states what the intent of the plan development is, and the developer is going to look at this and see how they can best meet the purpose. And the more they show meeting a purpose, the more it shows the public interest being served. Okay, does that answer your question?
Yep, it does. And then on the landscape buffer strip, so often what I've seen is a building, a commercial building, that has a back pathway that allows staff to move either toward eliminating garbage or entering parking areas. And they buffer themselves to a residential area where there's just a fixed wall. Are we making any kind of provision for that,
I'm sorry, I'm having
as
a little-
opposed to landscape wall?
Well, they need to have a landscape buffer. Whether they'll need to put a wall along there, you have to have a hedge right now under the ordinance, the way it's been proposed. So you would have to meet that minimum performance standard. Now, other things could be put in depending on what kind of development it is. I mean,
So those would be waivers.
I mean, well, those would be things that you would look at when you do the conditional use approval of the site.
That's an
If that's a
individual
necessity.
criteria on this particular application
Right.
as it come before us, and then we would decide whether it was adequate
Yeah.
to meet the
Yeah.
needs.
I-
In some case, that may be a situation where it's
It may
another
not-
commercial property, you wouldn't need it. In other places that were private residents, and we would want to give them more protection.
I don't think you're going to
Property.
see a lot of these along residential anyway, just because of the locational
Where they're-
requirements.
yeah.
So that's not going to be probably an issue.
Are the buffering requirements any more or less than the existing code?
They're additional to what the existing code is. Most of the buffering requirements, we don't have a lot of buffering requirements. We do in the new overlay district, and I'm trying to think. We don't have a lot. That was one of the problems we've identified in the ordinance. But you see that happening. Other than the landscape strips, you'll see we do have a lot for parking and that. The only place we really get in the buffering is you'll see in the POI, where you'll have that in some of the conditional use
Okay.
things.
And then page 6, the items that can be located on a rooftop, the equipment, et cetera, are they going to be calculated in the heights?
They're going to have to meet height requirements. They have to meet everything in our code
Okay.
for measurement of height. Yeah, there
So
is
there's
no
no-
exemption from height requirements here. No. And if you notice, we don't put waivers in for that either.
Okay.
Now, that would trigger the R word.
Yes, it would. But actually, under state law, you can't do a referendum on that anymore. So you would actually have to change the charter. You could not do a referendum on a development order. Yeah.
None of
Yeah.
height and density?
No,
That
but
went
you would
away?
have to. It would have to be on the referendum on the charter itself. So you would have to be, but you couldn't do it on an individual site plan that came in or somebody wanted. Like we in the past, you just can't do it. The Florida legislature just turned that, just enacted that rule.
It's interesting.
Well, a lot of work has gone into this, Tim.
Well, I did have a
It's
lot of
good.
help because what you didn't see, I had worked closely with Mr. Kite and Kimley Horn Group, and we had several reiterations, and it actually was sitting dormant for over a year and a half until now they want to really move forward with the project. So we wanted to get this before you. So we've had some time on this. Yes.
Are we ready to call the question on it?
Yes.
We are. Looking for a motion.
So moved.
We have a recommendation. We accept it in total right now. We have a second.
I don't.
I second.
Joe seconds it. It's been first and second. Any additional discussion? Seeing none, then we're voting. All in favor, say aye.
Aye.
Opposed, nay. It's 4-0. I shouldn't have said nay. Unanimous. Eventually, I'll catch up here. The second item then is 4B, and I'll read it also. An ordinance of the City of Vero Beach, Florida, amending the code of the City of Vero Beach, Chapter 60, Appendix Definition by revising the definitions for boarding house, community residential home dwelling unit, family multiple family residential structure, creating a definition for a rooming house, providing for conflict and severability, providing for an effective date. I'd like to open it up then for Tim. Do you have any comments first before?
Well, we had a detailed discussion. I just want to go over briefly a few of the points that are being covered here before I go into. I mean, the changes are pretty straightforward, and we can discuss those. The emphasis for this whole thing was to deal with the boarding house issue, and I think the attorney and I had pointed out previously that this more than 3 unrelated persons did not pass a legal challenge on that from many different points, particularly our constitutional issues, equal protection, right of association, and compliance with the Americans with Disabilities Act, including the Florida Housing Act. It was clear that we couldn't do it. Plus, it didn't recognize protected persons, such as disabled and all that are under these acts. So we needed to address it, that situation. And as I said, it didn't. Just that whole definition, it was also in our definition of family, didn't fit the modern American family anymore. So we would have numerous violations that would be considered a boarding house. And I think one of the problems we've always had with this is that we didn't deal with how the use was being done or characterize the use. It was done by how many people are related, which is a poor way to try to regulate anything. And I go into detail in that in the report how difficult it is to do that, and what problems it did, and what it led us to the problem with the boarding house. Clearly, we had the cause celeb, we'll call this. We had 4 unrelated people living in the house. But the problem is, the attorney and I both had problems with how the definition of that is, and when we did the investigation, we could not find anything under our code because we don't describe a boarding house to enforce anything. But apparently, people were living as a single household, but in some ways not. And clearly there were other external signs, a lot of parking on the front lawn and all that, which can be dealt with. So we need to do something to deal with that specific issue and defining the boarding house that was legal and fair to everybody involved. So we needed to put some strength in the code. So you notice that's what we've done here. In fact, we've added a few things. One of the things we're able to do is we've also put in some language about offering for rent, which you don't see. That gives us some inroads into places. We do have to define if they're based on the code where they're meeting what our definition is, but that gives us a little more leeway to do enforcement on these type of things. Again, I get back to it. Enforcement of these are very difficult. We just can't enter a house without getting the owner's approval or one of the tenants to allow us in there. And we're not going to be able to go to court. They don't raise to the level the court's going to give us an inspection warrant to go in there. I can tell you that. It just doesn't raise to that level. So we need to define this thing so it's that we can not only both the property owner knows what can be done, but my code enforcement people know what can be done. People know what's expected. And that's what we're trying to do here to clarify this. We also looked at the definitions of dwelling unit and family, and I said we got rid of all the unrelated and try to make it a single integrated household. So we try to do our best. One of the things we did under the family, we did deal with the idea that if you have the storage, consumption, and preparing of the food in one area that was isolated from all users or tenants in the building, then that would be declared another dwelling unit. So that's one way to try to handle it, because you find in typical in these things where people are being rented rooms out and they'll have almost everything in there, even though there's one kitchen in the house. They may, especially if they're single, the single lifestyle, you got a microwave, you come in there, you don't, and you may have a separate entrance getting in there. You know, they're really not living as a integrated household. And clearly, we get back to these kind of the worst aspects of a boarding house do have negative impacts, adverse impacts to the neighborhood. And we've been talking about that. Mr. Hunter just went through on the vacation rentals. You could say the same thing about boarding house. And one of the concerns we have is that these kind of uses, if they're not have some regulation to them in a better way, and we're trying to do that, that they can lend themselves to transit residential, where you have lease agreements that are easy to break. People can move in and out. But trying to, define what, trying to pinpoint those violations of code is very difficult. And I keep reiterating that. I'm not trying to make excuses. I'm just telling you how difficult it is. And we're trying to clarify that. So let me just go into.
Could we, Tim, you want to open a public hearing first? Public comment?
Oh, okay. I was just going to go over the definition. That's fine. If you feel it's okay, we'll just open it up. It's okay. It's up to you.
I'd like to open it up for public comment. How many people would like to speak? Can I see? Go ahead. Just try to follow suit on me.
For your record, my name's Michael O'Hare. I'm a lawyer with offices on Cardinal Drive in Vero Beach. And I'm here on behalf of clients on Banyan Road in particular, who are homeowners and residences on the street of many years standing. And there is on the street presently what has been defined and what will be a subject of this new ordinance, or a modified ordinance, a boarding house. And the people I represent are concerned about things that you already heard about, I'm sure, such as parking on front lawns, 6 or 7 vehicles per house, things of that nature. There is a constant turnover of transient residents who really don't have any skin in the neighborhood game. They don't have any investments to protect. They're not going to be there for more than 60 or 90 days in the usual case. And they have a detrimental effect on values in the neighborhood, simply because of the turnover, transients moving in and out. And I don't say transient in a pejorative sense. I mean, people who are short-term renters are going to be using these sorts of facilities. And for all practical purposes, they become public lodgings, a commercial venture. Well, they are commercial ventures. The landlord is making the money. In the case of the property on Banyan, the landlord is not a resident of the property. It exists for the sole purpose of being rented out room by room. Now, it's more far-reaching, though, than the immediate impact on the neighbors. There are, and I think reference might be made in the ordinance and the modifications, there are public health and safety issues involved in an operation such as this. Fire protection, for instance. There are no permits from a fire marshal, which is required of a motel or a hotel or a guest house. And, when you think about 4 or 5 different bedrooms or different rooms, each with its own hot plate or microwave or toaster oven or all of the above, you've got a lot of potential fire problems there. I'm confident that it's unlike a hotel or a motel, and then on the back of the door of the room is a chart showing exactly where you are in relationship to the exits from the building. And all we need is one terrible accident, and it's going to be a serious, serious thing. More than that, if you have centralized or common food preparation and storage areas, there's no health department monitoring of these operations. And there is nothing like tuberculosis testing, for instance. All of that sort of thing which relate to contagious diseases, bacteria prevention. And I would recommend that anybody proposing to have such an operation be able to produce appropriate permitting from the fire marshal and from the health department for the operation of the facility. More than that, I don't have to say. I think all of the things I've said, when you think about them, are pretty obvious. And some of them are downright hazardous. Some are just annoying. Bed bugs, for instance. Nasty, but annoying. But it's not just the neighbors raising a ruckus. And my clients have raised a ruckus with Tim. I know that. And have stayed on it and will continue to stay on it. We need something that can be enforced and that will be enforced. The current enforcement mechanism, I believe, and I'm looking to Wayne or Peggy on this, is Chapter 34, Section 34.08, which is the definition of a boarding house, and which provides a $100 a day fine, which coincides or approximates a code enforcement violation fine, and it will accumulate from day to day as long as it goes on. I don't have a problem with that. But is that the enforcement mechanism?
Well, that's the fine in there, yes. It's
Yeah.
the $100,
Yeah.
right.
So I would encourage you to proceed forward. I want to see Tim with all of the tools he needs to move vigorously to prohibit this kind of thing continuing. You've got a bunch of scofflaws out there, and apparently they're more scattered around the beach area than I was aware of until I got involved in this. But they seem to be in several locations, and they're all operating under the radar. Needs to be stopped. I'll be happy to answer any questions.
Do you have a question?
Do you have any other suggestions beyond the fines?
Well, the fines are there. They're in place. I think they're probably adequate, but if they prove to be inadequate, I'll be talking to you again, I'm sure.
Raise them. Yeah. Okay.
Mark?
Mike, at the end of our workshop, we still had some disagreement as to whether, a little old lady or someone who has having trouble paying their mortgage had the legal right to bring in a boarder, maybe a single boarder, maybe rent out a room.
Or even a boarder-come caregiver.
In a single family residence. Have you looked into that at all?
I believe Ted and Wayne have addressed that. Have you not?
Yes.
Tim?
Ted. It's all right, Michael.
Well, you've got to carry some water here.
For use.
No. Yeah, we looked into that, and there in some places, I think we looked at the California, and their attorney general said you could do up to two or more, two, and it'd be okay. We feel comfortable. The whole idea is whether it's split, giving some property rights so people could do certain things. So we said
You've gone to 3, haven't you?
No.
No?
The way we're
The newer one would be one.
Yeah, the newer one would be one. Yes, and that's what we felt it gave you the homeowner, a property owner, that opportunity.
That
to do
leeway.
that. Right.
No, I'm not even sure. I feel good about that. What the experiences have been in different neighborhoods, with people renting out rooms in a single family neighborhood.
Well, if there were 2 tenants, perhaps that would be a livable situation for the neighborhood. I mean, the situation you're talking about is more likely than not to be more permanent than transient, one, and not to generate a lot of automobile traffic and vehicle parking. So that,
there was only one resident and one tenant.
Exactly.
I think that's the way we ended it, was that they determined if more than one room or suite was being offered for consideration. Yeah.
Okay.
All right. And then is it possible a lease requirement and a length of lease requirement so we don't get into this bed tax and things?
Okay.
To me, somebody paying a bed tax is counter inherently counter to a single-family neighborhood.
Well, here's the problem. Okay. We didn't put leases in here because that will be one of our – we can use that as part of the whole case. I mean, looking at if we get into one of these cases and how there's a lease, that would help us. We had a discussion of that, and Wayne and I decided to leave that out. But that would be something we would look at if we were to enforce this. Now, but getting back to what you're bringing back one of the issues here. We get back to our vacation short-term rental. We're using the 30-day rule, so as long as they're in there 30 days, the question is if we start, anything under 6 months and under is a bed tax. That's automatic. Under the state law, and Mr. Hunter pointed that out, if it's 30 days and less, you need to have a license. But anything under 6 months, you have to pay a tax to other things. So the question we get into is, are we now getting into vacation rentals when we start getting to the transit residential? And that's why we're very careful not to bring that up. And we haven't really.
Well, that's what I'd like to see. If we're going to allow people to take in boarders, if you will, or rent out rooms in a single-family neighborhood, I think it ought to be a 6-month minimum.
And I have absolutely no problem with that. I agree with you. Anything less is almost by definition transient.
Absolutely.
Yeah, I guess we're trying to protect our vacation rental part of the whole ordinance too. So I don't know what else to say. So that's why we didn't get into any of that kind of because somebody could bring that up and say we are now. And Wayne can add to this.
I'm still confused about a vacation rental versus a boarding house and what the difference is in a given neighborhood.
Well, no, the time period is really the differential. If it's rented out for less than 30 days, Tim would probably enforce based on it's a transient rental.
Right.
It's not permitted in a single-family residential district. It's more than 30 days.
Where?
It seems
all we can fall back on is the boarding house.
Right. So then we determine whether it's being operated as a boarding house under the new definition, not the length of the tenure. So
it seems to me the problem here is when we meet the more extreme situations where it's multiple people, multiple different unrelated people coming here. I don't know that we've ever had one comment of one person renting out a room to somebody. If that's come before us, because that person drives one car, they park in probably 2 spaces. Those people can probably fly under the radar forever. It's when you have multiple people, multiple cars, a lot of children moving in and out that the problem occurs.
I agree. Well, with all these, that's where the problem occurs. You have a lot goes on in the city that nobody noticed because they're good neighbors. They don't allow things to happen, and it doesn't come up to us. Where you have problems that occur, such as this residence occur, it clearly came up. The neighbors were clearly alarmed by this, and that comes to the forefront. So here we are. We're making regulations try to deal with this. But you're right. It's the kind of thing. If you're a good neighbor, and that a lot of people wouldn't even know you're doing it. But when you have a changeover or different cars, people are parking on the lawn, it's pretty clear that something else is going on.
Mark, as our world evolves here a little bit, we maybe have to go back and modify, make a few changes when we can, put more teeth into the ordinance. And the way we're looking at it today, I believe we should be looking at it more to, is this a good start? Is this as much as we can get today? And if it doesn't work, then we have to go back and try to modify it again. If it does work, then we've accomplished the problem without irritating everybody that wants to rent out a room to, if somebody help them, whether they're ill or they just need the additional revenue.
But we're not talking about one room to one individual. We can be talking about one or more rooms to one family, which might have 2 adults, might have
2 children,
unspecified number of children, and there may be 2 of those. I think twice as many of those kind of people in one.
Well, they still
modest house.
They still have to meet the housing code. Right. There's so many square feet per person in the room, so we still have that. So that's the other thing that's the capacity constraint.
When
Mark,
you have more than 4
let me
adults,
suggest this to you. I'm not quarreling with any of the points you make, but let me say that you've got to start somewhere, and Tim has not had anything he could work with to this point in time. He and Wayne have tried to come up with something that's manageable from an enforcement point of view. It's a good start. I think if problems arise along the lines you're considering, as Tim says, it can be tweaked down the road if and when those problems arise. And that's what I would suggest to you is the way to go. We need to start somewhere, and this is a good place to start.
I don't know. I just see allowing two families, if you will, or even two unrelated people. I know the ACLU won't let us define unrelated people as a measure, but I just see that as counter to the single-family residence concept. I could have my single-family residence and have two families on one side of me, two families on another side of me, two families.
And you're
across
into
the
multiple
street.
family, is what you are. Yeah,
That's multifamily.
I agree.
I have a problem with making it too complicated to begin with. I think Tim's right, and this gentleman is right also, that this is a good start. It identifies the significant problems that we've had the most trouble with, and it clears up the definitions that will address those issues. But I think we need experience with it. And so I think this is a great start. As we get experience, we may be able to find it necessary to redefine certain little aspects of it to make it more precise. But I think this is an excellent start, and I think we ought to move on it from that point of view.
I would agree that it's better than nothing.
Well, that's pretty much what we've got, Mark.
Yeah. And that's
Can
right.
we-
We were just pointing out, if they create a separate dwelling unit, then they were in violation of the other part of the, then they become multifamily. That's another violation. So,
I'm not talking about a separate dwelling. I'm not talking about two kitchens, but as you said, everybody has a refrigerator, a microwave, a hot plate.
well, that's why we try to put a little more verbiage into the dwelling unit or the dwelling unit definition to try to cover some of that.
No matter what we do with this ordinance, I think the most difficult part of it will be enforcement, because there's so many counter arguments to what you do and trying to get access and to pin them down. So I think if Tim and our legal procedures can help, need help, we can get back and amend and tweak this until we get it right. Any other questions for?
Yeah,
I'm sorry.
I've always not for Mike, but I've always said
Thank you,
that
Mike.
the secret to a happy marriage is separate bathrooms, and I wonder, I wonder how this going into a one-bathroom home would work out from a health standpoint or a domestic tranquility standpoint.
I lived in one of those all my life, so I can explain to
Yeah,
you.
but how many other people live there?
I could go along with that with 7 in one home, so it
one
can
bath.
be done.
Yep.
I'm David Hunter. I identified myself earlier in this meeting. On the question of boarding houses, I have a couple of thoughts and suggestions. First of all, since this is spreading out, as the previous speaker said, possibly sub rosa throughout our community, the first thing, if anyone notices such a suspected boarding house, they should report it to code enforcement. Mr. McGarry said earlier that he can only act on violations if they're reported to him. That's why the earlier reference about the Carroll's property, it had been going on for years, but apparently nobody had reported it, and therefore he could not take action. So, and it's very easy to report it. You go on the internet to Code Enforcement Vero Beach, and up pops a website, and you can then enter in your complaint. So it doesn't take very long. I encourage people to do that. As far as the further aspect of code enforcement, if they're investigating a suspicious alleged infringement, be it public lodging, boarding house, or vacation rental, I would like to at least raise the question that if someone misinforms themselves about what's going on, misinforms the code enforcement officer, This should be considered to be an obstruction of justice charge in the same way that lying to a police officers and code enforcement officers are both law enforcement officers. And lying to a law enforcement officer is obstruction of justice and is subject to penalties, up to $1,000 fines, as I recall. So I think this is an aspect partly that we should be using in our enforcement of the violations. And the second area that you mentioned about fire problems with multiple dwellings, I talked to a fire marshal. Tim, can we just wait a minute? I talked to a fire marshal myself for the Indian River County, and he, actually it's a she told me we can only inspect units that are 3 units or more. Now, that was the Indian River County Fire Marshal. First of all, the question is, why is that the rule? Who made that the rule? And secondly, if you have 3 or more people in a boarding house who are living in separate areas of that boarding house, almost as separate units, why could that not be inspected by the fire marshal? And frankly, it should be inspected, as some of the council members have said. Mr. Mulcher, I think, mentioned that it would be dangerous to the tenants if they are in a property that doesn't have adequate electricity and they've got overloading of the power. And a lot of these old houses have not been upgraded, so they represent a danger. So this raises another question for the board. What would be the restriction on having code enforcement check lease agreements in suspected boarding houses and say, I want to see your lease agreement. Is it for 30 days or less? Is it a transient rental, in which case we can act because it's a transient rental? Or is it a 6-month or 3-month rental? I don't see why there's any reason it should be public access if it's a commercial lease agreement. That's not a private transaction that's restricted from public access. In fact, if it's a rental of less than 6 months, they should be paying bed tax on that rental. And that bed tax is a public record as well. So I think that it would be reasonable to request in an aggressive code enforcement program to request the lease agreements be displayed or shown in order to confirm that they are not running a transient public dwelling establishment. That is, transient public dwelling is less than 30 days. If it's less than 6 months, you still pay bed tax, but it is not a transient public dwelling establishment. It is merely a public dwelling establishment. So anyway, I do think that the fire marshal could possibly be engaged if you were to show that there were 3 leases or more on a property. You could argue that that's 3 dwellings on that property. There's nothing that says 3 units that are 1,000 square feet each should be inspected by a fire marshal, but a 3,000 square foot house that has 4 families living in it shouldn't be inspected by a fire marshal. It doesn't make sense. And that's for the safety of the people that are in there, as well as for our ability to enforce the community standard. Okay, thank you.
David, let me correct you on a couple items. I don't believe that the leases are public information or that we can demand them. Plus, I suppose you're correct to some extent about the code enforcement officer, but if I was doing this sub rosa, as you said, I certainly wouldn't produce a lease that was going to be to my detriment. Secondly, I was having a beer with Jeff Smith the other day, and he told me that the bed tax and, in fact, the regular sales tax is not public information. So whether or not the city would have to subpoena that information or what, I don't know.
Well,
it does make it difficult.
I've talked to Jeff Smith myself, and in fact, the county is currently conducting a countywide audit on the payment of bed taxes and of properties to be sure that those that are being rented out for less than 6 months are being compliant in paying bed taxes.
Well, I think we're saying 2 different things. They obviously can audit that kind of activity. Whether what he said was, I can't go in and say, did did David pay his bed tax? And if I can, I don't believe Tim can either, without some kind of a court order.
Well, that might be worth having a meeting between the city and the county to discuss, because I do think that there is room for getting the county. I've been actually talking to the state, and the state is going to be providing the county with information about the licenses that are required by the state. And I'm hoping that the state is going to send a representative to the county very soon to conduct a briefing about the requirement for state licenses for certain types of activity. And obviously the taxation issue is different from the license, what's called the commercial license. So it does get complicated. And you're right, you've got state, county, and city issues all to deal with. But there's no reason why the state and county should not cooperate with the city in order to assure that licenses are properly held and that taxes and financial obligations are being paid correctly. There's no reason why the three units should not be able to cooperate on that.
Well, I just want to say in our enforcement action, we'll call the state on licenses, on the DPR. 30 days or less, they have to have a license. We do that. We contact the county clerk's office for dealing with.
Is this all written?
We do. Yeah, that's what we do routinely in all these. But I believe what our problem is, you can maybe get how much money's being paid in, but you don't know where. You can't link it to any property. So that's been one of the issues there.
How can you get a license for 30 days if 30 days is illegal?
Well, they don't look at. This isn't like an alcoholic beverage where I have to sign off on it. And, alcoholic beverage license, I sign off that it meets the zoning. We don't get a sign off on that.
So if we got a list of all 30-day or less licenses in the city, we could just go shut them down.
Yes, go ahead.
This suggestion of obstruction of justice, is someone is lying to you, is there any credibility behind that? I mean, in terms of what could be enforced?
I don't practice criminal law anymore, so
I look at it like
we only enforce ordinances.
When was the last time someone was prosecuted
I don't
for perjury?
know off the top of my head.
Yeah.
That's an interesting concept.
Charge or not. And actually, code enforcement officers are not technically police officers,
law enforcement.
But law enforcement officers in the city are classified as they are also code enforcement officers. They can enforce the code. Code enforcement officers cannot enforce anything other than our code and the regulations that come under the code.
If I can, I've investigated this myself, and there's a distinction. A code enforcement officer is a law enforcement officer. A policeman is a law enforcement officer. Both of them are law enforcement officers. The issue of a false claim or report, a false report, applies to law enforcement officers. It is more commonly prosecuted when it is given to a policeman. But a code enforcement officer is enforcing the code, which is part of the law of the city of Vero Beach. So it is a law enforcement officer, and misleading a policeman or a code enforcement officer could be considered obstruction of his conducting his investigation. So there should be some penalty for that if they're lying or misleading or obstructing.
Yeah, I'm just looking at, strengthening the enforcement things. That's a credible thing to, insert. The other...
What's the penalty for, what does a code enforcement officer do if they know someone's lied to them?
They would bring a misdemeanor charge. It would be a civil charge, I suppose, but be a misdemeanor charge against the police can do that too. If you lie to a police officer, that's the guy that carries the gun and wears the uniform. They're the policeman. But if you lie to a law enforcement officer, you are doing the same infraction. You are obstructing the enforcement of the law. So I think that we need to lean forward on this whole concept of enforcement. As I said, higher fines, more if people lie to you about the enforcement, about what they're doing, that as a code enforcement officer, you should be able to take a penalty against them. The concept of being able to to actually enter a property. Do you know that the state of Florida license that is issued for resort dwellings, that is supposed to be posted on the inside of the property, just like a hotel license is. So under certain circumstances, a code enforcement officer and or a police officer should have the ability to go into that property and look at that license to ensure that it's there.
My only comment to you, David, is the real world may be a little different than that. You can figure out, there's so many rules in this world, nobody can comply with all of them, okay? My point to you is that, is it practical to go through all this effort? And I think what we have to deal with today is what we can do in the ordinance and what we can turn over to the people that enforce those and let them make those kind of decisions. Because you and I can discuss that all day long, and I have no expertise in that area, and I leave the people that enforce it do that work for me and for the city.
Right.
Thank you.
How difficult would it be to increase the fines?
Well, that's something we can look at. But we start raising these fines and we're increasing across the board. So I think what people forget that these fines can escalate. And if we go down, we can do it by the day if we get we've been very cautious on this because of the nature of this whole thing and what we can do. And I'm talking about vacation rentals right now. So we start at 50, the next time is 100, but we can go to each day we could be fining. And we just haven't done that, we're hoping for compliance here. And that's the whole idea. You know, as Mr. Hunter pointed out, we already have hopefully they won't do it again and they learned a lesson. And that's what we're trying to do.
What kind of time frame do you give for compliance?
Well, the first time around on a warning or the citation, we normally let the length of the tenancy, since they have a contract, to run out. After that, we have not gotten to that point where I've had after the $50 fine. We've not had experience for that. So we would have to do it on a case-by-case basis. But certainly we've talked about it that we could do it each day, go by, and fine them each day.
Have you ever had anyone come into compliance?
We just heard.
Yeah, this one.
We just heard that, and we have others that we have to drop the case because they'll either, we'll send them a warning that, hey, you're advertising. We have reason to believe you understand you're in violation of the code. They'll change their advertising. We do keep an eye on what's going on when those come to our attention, and we follow up on it. We just don't.
And that's all documented in the department.
We have case files in everything we open. All right, and we follow up. As I said, we do these on a complaint and basis, and we follow up where we can, and we will do the best we can to enforce the rules.
Any other discussion? Please proceed.
Thank you, Mr. Chairman, members of the board. My name is Barry Siegel. I have the pleasure of representing Irene Snyder, she resides at 655 Banyan Drive. I introduced her. She's sitting here in the second row. I introduced her to the fact that this is very much a witch hunt. And just for the record, my address, 621 17th Street, here in the city of Vero Beach. This is a situation that's been going on for decades and is only now become an issue because Mr. O'Hare's client has believed it's an issue, and so now it's become an issue to the du jour. I'm not so naive as to not be able to take a temperature of a room and understand that this is an issue before the board, and I can understand the importance and the significance to all of you. But I think what we also need to do is take a step back and look at, first of all, what we have in the code and what is the problem here, and are we solving the problem? And I can say with all those, we really are not addressing the issue in a most peculiar way that's going to protect property rights of our citizens. This also going to accomplish the goals that this board is trying to pass on to the city of Vero Beach. Everything that I've heard complain about, with the exception, I think, of the tuberculosis and the bed bugs, I don't know what we're going to do in the code about those, are already addressed in the code. Transient rentals, my client has no interest in renting to transient rentals. It is illegal. The code already provides 30-day rentals and less than 30 days are prohibited. That is not an issue with my client's situation here. We have issues with overuse of the house. Mr. McGarry's made it clear. Your code protects you in this situation, protects the citizens. You can put so many people in so many square foot of so many rooms of a house, period. Those protections are in place. There's parking issues with regard to can you park on lawns, on streets, on right-of-ways and thoroughfares. You have code provisions already in place to address those issues. My client does not rent a 4-bedroom house to 13, 14 people. She does not put one whole family in each bedroom. Typically, she has rented one room to one person, and it has not been a problem for her in the city of Vero Beach going back to 1992. This is not a new situation. This is not a new occurrence. I understand the concern and the significance of transient vacation rentals. That is a different animal. That is not the problem that is before you on this ordinance. I think that the law is in place to protect you for that already, and you're not going to address that with what you're doing to my client or what is proposed to be done on this situation. As I listen to this, the one thing that comes to mind, and I bear no offense by saying this reminds me of Obamacare. We've got this situation out there where we throw around all kinds of concerns and cares, and we say, hey, we need to address this. What's going to be the best for everybody? Let's put in this big sweeping provision. And the reason I say that it reminds me of Obamacare is to hear you say, let's throw it out there, and then we can adjust it as we go. And that's what we're finding out with President Obama and Obamacare. They put out this big dragnet of a venture to cure a perceived problem, whether it's tuberculosis and bed bugs and fires, oh my, or what have you, and then we'll adjust as we see if it causes problems. Well, we've already seen that you can't even enact Obamacare because we did this to try and cure this, and now we've caused this problem. Well, the problem you're going to have with this ordinance as it is written, as it's presented, failing of which it's not going to prevent the problem that you're concerned with, but it's going to put all of these other people into this dragnet. If you've got a mother-in-law suite, done. You're out. You can't do it. If you've got a situation where you've got a live-in nurse that part of her pay or part of your agreement with her is she gets to live or he gets to live with you as part of their compensation, I believe that's the point you were bringing up, done. Can't do it under this. You are going to have so many unintended consequences with this enactment without accomplishing what you're trying to accomplish, but you're going to have so many of these enactments that are going to dragnet and sweep in everyone's personal property rights that has anything to do with other than living in the home by themselves. And that is not what you need to do, and it's not what you intend to do. This will not fix your problem. The problems that I pick up from listening to people is the transients. You've got it in place. And perhaps the city looks at making that a longer threshold. You've got in place the overuse of the property. You can't occupy it or build it out more than it already exists. You've got a problem here where you're specifically targeting one person, and I certainly don't mean that the four of you or even Mr. McGarry are targeting her specifically, but that is what's going on here. You've got a perceived problem from one person that is raising an issue very loudly. I'm not saying that Mr. Hunter's issues aren't placed as well, but you're trying to fix a singular problem with a dragnet that's going to have a lot of unintended consequences, and you're not going to fix the problem. My client does not have a house where each room is independent and lives on its own with refrigerators and stoves and microwaves. That is not the situation. It's a house that a person has owned from 1992 that she has rented out no higher than the occupancy that is allowed, and most typically she's actually rented it out less than she's done. She's got the city's asked her to get leases. She's put the tenants under leases. None of them are short term. None of them are. I think that we heard the word derelicts and scufflaws. I think was in there as well. I don't often get to use that word, so I'm pleased to bring it for you today. But that is not the situation, and you're not going to fix what everyone's complaining about because the fix is already there, and it's just something that needs to be enforced. You're going to create a situation with this ordinance that will be almost impossible. And let's not even start considering the expense associated with this law. If this ordinance is put in place, are you going to go door to door, look in the bedrooms and see which one's got a hot plate, which one has a microwave, which one has a sink, which one has a bathroom? Are you going to check all those things? You're not going to. It's not going to be feasible. It's not going to be practical. If you've got people, you say, well, fine, you've got leases, but they're going to just do a long-term lease and then they're going to, just constantly breach it. Well, something like that would be actionable under the code. If someone is intentionally or has a pattern in practice of executing one-year leases and lets people out of them after 2 weeks, 3 weeks, a month, what have you, a paper trail exists. It is there. It is enforceable that you can accomplish the prevention that you're looking to prevent. This ordinance is written wouldn't prevent a fraternity house moving in next door to Mr. O'Hare's client. It's not going to be, and there's really realistically no evidence or testimony before you that even says that this action on behalf of my client affects the neighborhood. You can go back and you can talk to your police chief. You can talk to code enforcement and ask how many times have there been a problem at this house? How many complaints has the city received? And you're going to find that it realistically has been none. I think there's one issue a couple of decades ago that involved a car with a flat tire in the front yard, and the person that was living there filled up the tire with air or replaced the tire, and that was it. And so what I'm asking you to do is sell you. You don't have to do anything. We do not need to make government bigger. We do not need to go looking in each people's bedrooms. We do not need to go telling our citizens how do you use your property. It is not necessary. What you're trying to protect against, what you're obligated to protect against, is in place, and it's at the fingertips of code enforcement. And so at this point in time, it would be our intention to say, table this, put it back to staff, or just resolve to just get rid of this one for now. Deal with your transient issues. Those are the issues that are causing the concerns to the parties, not the boarding houses. Thank you.
I have a question. Mr. Siegel, you haven't identified your client nor the address, and I'm not interested in that. But you made a couple of comments that I'd like clarified. You said that you rented as the occupancy allows. Could you explain that, please?
The code provisions in the building code, and Mr. McGarry can probably even speak to it better than I can, certainly Mr. Comment and Ms. Lyon can as well. But the code only allows you to have so many rooms per square foot, and certainly the code lays out how you can structure those, how many rooms and how you can structure those rooms within a structure.
Are you referring to a single-family residence?
Yes.
Okay.
Or I think it probably even would speak to multifamily residences. That you've got square footage requirements as to how many rooms and what the sizes of the rooms have to be, and you've also got occupancy standards. How many occupants per room are allowed? My client is not doing anything that's not prohibited under the code. Is that responsive to your question?
Well, okay. I think as this ordinance is proposed, certainly a live-in nurse is permitted, yes?
Well, I think we said we could have, you could have one room or suite.
Right.
So I think what you're bringing up is not true. I mean, about not having a nurse or live-in, you could do it under
and then the
revised
mother-in-law suite, how is that
Well,
defined?
as long as it's you could rent out or have it, whatever, no compensation. But you could do that. She just couldn't have a separate living quarters,
So that's all permissible as we're going forward?
On the way this is written, yes.
Okay.
Mr. Chairman, Mr. Siegel, I didn't agree with almost anything you said, and I realize that you're here to argue for your client. But I'll just ask you personally or as a professional, what part of single-family residence don't you understand? What makes you think that if the law says you can have one person for 200 feet and you've got 1,200 feet that you can have 6 people in there?
Well, I don't look at it, personally, I don't look at it as a matter of square footage. I look at it as bedrooms. My client, this is not a situation where we've got a tent sitting in the living room or the dining room. This is a situation where if you've got a house with 3 bedrooms in it, it doesn't bother me at all that you've got 3 people living, 1 in each bedroom. That to me, absolutely, as a professional.
I go back to my question. What part of single-family residence and a single-family zoning district don't you understand? How can you defend against that concept?
I have no problem defending that concept with roommates. Certainly, all of us have had the chance to, whether in college or whether after college when we're young professionals, that we've had roommates. I have no problem with the idea of roommates in a single-family residence.
Well, we're not in a college town here, but and I assume there's probably some flight safety or Dodger situations that in the past used to take place, but again, with the concerns of the neighbors and owners of a neighborhood, and we're here to defend the rights of the neighbors as well as the rights of the property owner. But the property owner's rights are limited by zoning.
I understand that, and
no, you seem to want to just throw that out, and the property owner can do whatever they want.
Well, I actually, I look at just the code, is we look at everything from the Constitution, we look at many different federal and Florida statutes. When we look at this, and we can't just say, I'm only going to allow you to live here if you guys are related, if you're a family, as I call you a family. I mean, I know what you mean by family. I know what I mean by family. But we also have a totally different definition in this proposed ordinance of what's a family. But when I look at all of that combined, when I think of the Constitution, when I think of property rights, and they mean a lot to me. It's what I do all day for a living. When I think of someone's protected property rights, then yes, I consider that whether it's a college town or not, whether it's a flight safety student, whether it's a former Vero Beach Dodger, if I can use my property in a way that is not, and I grant you, detrimentally affecting the neighborhood. Now, if we've got issues with noise, we've got the police for that. If we've got issue with smell, with trash refuse, we've got code enforcement. You have the protections in place from that. There is nothing to say that a family is going to be any worse or better than 2 or 3 roommates living together in a home on the effect of the neighborhood.
Well, first of all, I don't think we're talking about 2 or 3. Secondly, I think you're arguing that a boarding house, an unregulated boarding house, should be allowed in every home in the city.
I don't have an issue with a home being used. The code permits for the loads. I definitely have an issue with the transient.
Well, if the code permits it now, that's about to change.
Perhaps, yes.
Barry, I have a question of you also. Can you give me the particular situation, because I don't know what the situation of your client is? Kind of give me an insight to where she is now and what we think this would do to that situation. Can you do that for me?
Yeah, I'll give you a snapshot of what we have in place at this house right now. We have a mother and a daughter living at the house. There is a gentleman there who is a pilot, and there is a 65-year-old woman that is on SSDI that are living in the house together.
Okay.
That's who's there. And truth be told, how will this ordinance affect him? It might not affect it at all.
And how many bedrooms are in the home?
It's a 4-bedroom home.
4-bedroom home. Okay. And how many cars are at that home?
My guess is 3 cars.
Okay. Now I'm going to ask the question of how would that impact this particular individual? If that scenario we said, I don't know that it does. The mother and daughter are one unit, right? And the pilot possibly and another individual.
Well, that's 3
one
parties,
kitchen, one
and we're
kitchen.
only allowing 2, right?
No, you can. I have more than 3.
Well,
cars
this has one kitchen. Okay.
One kitchen.
So, the mother and daughter, that could be one, and then you have one room, or you could have at least 2 in there. This would probably exclude the other party in there.
They're not related.
Well, no, that isn't that it is. We're looking at the rent rooms, and I'm just trying to.
And this is not owner-occupied?
Well, if they're under a nuclear unit, they're all under one lease, they're all living together as a unit, it's not a big deal.
There's no owner-occupied at all?
Yeah.
No, she doesn't live in this house.
See, if they're under separate leases and everything, they're operating not as a single unit.
Family, yeah.
I mean, that's clear. That's why we brought that up. That would be something to look at.
You see, Barry, I'm pretty much a property rights person and kind of probably would agree with you on an awful lot of things, but I think this is pushing the envelope beyond where I think if I was a neighbor I would like to see.
Well,
forgive me.
Well, let me pose this question to you. Where is the harm? Have we heard any complaints other than Mr. O'Hare's client? And what are the complaints of?
Well, if I was living next door and I had no problem with it, I would make a complaint, okay? But if I was living next door to it and there were, just say that each one of these individuals had a group of friends over or had a problem, then I think I would complain about it. So I'm on the cutting edge here of where I would go, depending on how these people lived in that unit, how they conducted themselves, whether I'd even make a phone call. In most cases, I think this would go under the radar as long as they're all doing the right thing. But in some cases, whenever they weren't doing the right thing, I want to have an ordinance there that allows the teeth in it to make it to correct it. And without doing what I think we're doing here, and I don't think the net's too large, I think we might. I don't think right now we have the ability to correct that situation effectively.
Well, here's the thing: where is the difference between 4 brothers that are living in a house together?
I agree. There's merit.
And so here's my issue: is that you're trying to cure a problem the wrong way. If you've got people living there, whether they're four brothers or the situation that my client presents. If you've got noise issues, you've got parties, you've got late night activity, if you've got parking on the grass, on the street, you have the powers in place to resolve those issues exactly the way you would handle it. If they're not being a problem, I don't care who's living in there. But if they're causing a problem, well, what are the problems? And that's what I think you really need to address. What are the problems that you're concerned with that this situation produces?
Well, in your case, it might not be producing it, but I think we have some situations where there is a problem and we should address it, and we couldn't address it effectively. And I think that's what we're trying to accomplish right now.
But that's the part that I'm having trouble ascertaining. What is the actual problem itself? Is the problem noise? Is the problem that we don't like the car? I mean, that's the...
Too much movement in and out of people coming and going, too many people being, well, I'll call them transients because they're there for a short period of time, not knowing your neighbors. A neighborhood is established with people who are neighbors. People that are coming and going every 6 weeks or 3 days or whatever it might be are not neighbors. Okay? They're not people you talk across the fence to. Neighbors are people you know and you recognize their habits and their lifestyles, and you can relate to them to some degree, whether it's positively or negatively. When you have somebody coming and going, you don't know what you're going to see that evening. As a guy come in, I know my neighbors right now, and I know they don't carry guns. I know they don't do crazy things. I adjust to them, okay? But when I have somebody different every week, I don't know how to adjust to them. And I'm afraid when you get to the point where we're having too many people coming and going, it becomes something that I don't think, as the neighbor to this property, that I want to put up with. And I think a point of reasonableness here is that we need a little more teeth in what we're doing to be able to accomplish that situation when we can't take care of it to the laws we have right now. And so far, it seems like we've been unable to, on a timely fashion, to take care of this situation. And therefore, I think I'm leaning toward the fact that we need to do something with a little more teeth to see if it can help. So when we do have this situation, we can take care of it more promptly and more effectively.
Well, and see, I have trouble escaping
Mr.
that.
Siegel, one comment.
Yes.
The kind of things that he is just talking about have produced, and that we're trying to deal with in these codes, have produced increasing evidence, okay, that the living conditions we're trying to ameliorate here are producing more and more of the very kind of violations that you are talking about. And so what we're trying to do to some degree is get to the base of some of the causes of these violations so that they won't happen in the first place, so that so the neighbors don't have to be calling code enforcement and the police department about cars and wild parties and trash. And you understand what I'm getting at? I mean, that's the basis for the whole thing. Try to ameliorate the situation that is producing more and more of the very kinds of complaints that you're talking about.
And I understand that, but I don't know that the evidence is actually there that this is the situation, or even this type of situation is what's producing it. I very much in touch with the need to eliminate the transient and the vacation rental. I have no problem with that. I think that you're probably online and on target with trying to eliminate that. And I would say that if you had to do something like this, that you could add some teeth to it in the form of adding a length of time restriction to it. Because, again, the basic fundamental property rights that we're talking about violating with this are not outweighed by the evidence that's presented that this situation is causing the type of problems that you're talking about, especially when you have the mechanisms in place to affect them. We can't sit here and say that we respect our constitutional rights to use the property freely when we have other avenues to protect the rights of those around us. I will tell you, if my client finds of a party in her house and there's a noise issue, she'll probably be the one calling the police and code enforcement before anyone else does. So,
one thing I hope this is to wrap it up, but I don't know how many clients that Mr. O'Hare has, but if this situation in her home, in your client's home, is as rosy as you say it is, I doubt they would have lawyered up.
Why am I here?
That's right.
Exactly.
And his client's not here to answer for it, and I don't know, and it's really not that big of a concern of mine. I mean, yes, someone's dissatisfied with it. It may have nothing to do with anything. It could be a misconceived notion. Frankly,
that could take place with one neighbor, but not with a group of neighbors.
Frankly, I think that it's a form of profiling and stereotyping. Period. Nothing else. Nothing more. The people that are in there now, and that have been there since 1992, have not produced a single comment or complaint that can be established on the record by code enforcement, by the police department, by this board. There is a stereotype that's attached to it. If we're going to do this, then let's take this step further. Let's prevent renting of property altogether, because renters, by their nature, are transient people, and they're going to come in and they're going to come out. I know that's an extreme overreaction to what you're saying, but at the same time, you're trying to prevent a harm that is not there. You're trying to prevent a damage that is not actually occurring.
Okay, well, I don't think we're going to convince you. I think you're going to convince us. So.
Right.
Having these 4 people live in that home, is that the kind of situation that required licensing and taxes and that kind of thing?
Well, not if they're operating under there. They don't have to be licensed by the state. If they're long-term rentals, they're not paying it.
Right.
Did they produce the leases to you? You
she
suggested
has
that
made
they
some
got
leases, but leases are only as good as what they, you know what I mean? Again.
So is this the kind of thing that we now can get into our code or into our enforcement?
I'm sorry, what kind of thing do you mean?
Well, with leases and licensing.
Well, I mean, that
and
certainly
bed
is
tax
something that could be provided. We'd ask for, and Miss Snyder's been very cooperative with us, and has allowed us my people in there, and she's shown us we have lease agreements that she's shown. But she wasn't operating with lease agreements when we first came to her. She had those done later. So I said, lease agreements are one thing. I mean, I still think, despite all this, if people are not operating as a single-family house and you have multiple strangers together that are not bound together, at least under some lease agreement, that they at least have some relationship to be a household, they don't have to be related or anything, I think you can end up to have some problems. And I disagree. We've had some code enforcement issues at that house just recently with one of the tenants. So, that doesn't mean, but he's right. Your neighbor next door could be doing the same thing. I mean, it doesn't mean because you're a renter at this place that you're an evil person. I mean, we're not after that.
Yeah,
it's just
not the point
that we believe, and I think the records show, and that's why a lot of states or municipalities have dealt with this, is these relationships where you have maybe 3 or 4 leases or whatever. People, there's no commitment as a household, and therefore the complexion there's more changeover in people and that kind of thing. It's just not the same, and people get uncomfortable. Yeah. Just like at the vacation rentals, when you have strangers in your neighborhood, they may be acting all right, but you move into your single family or whatever, your residential neighborhood, and you want quality of life, and you want to rest assured everything's okay, and you got people you've never seen that keep showing up all the time. Your security tends to be threatened.
Stabilize your neighborhood,
right.
Sure. Yeah.
Okay, just one comment.
Thank you, Barry.
Thank you.
Linda Hillman, 2315 18th Avenue. And yes, it does have a great impact on the neighborhoods. As we know, in the original town where I live, 16th Avenue, 15th Avenue, 18th Avenue, 19th Avenue, 24th Street, 22nd Street, all of those homes were single families. Now there's multiple people living in those homes. On 19th Avenue, we have the Coral Apartments, which I have and several neighbors have called code enforcement, the police. That is transient traffic. There is not one day that you can sit on the corner of 23rd Street and 19th Avenue and tell me that you've seen that person come out of that apartment dwelling twice. It will never happen. And we brought this up before to code enforcement. They've gone out, and the owner who does not live in the state claims it is not a transient apartment dwelling. Totally false. Totally false. I've gone out at 1 o'clock in the morning in my alleyway of 18th and 19th Avenue, chasing people away who have come out of that apartment and started arguing, swearing, cursing. 1 o'clock in the morning, calling the police to get my sleep and sanity back in my neighborhood. On 16th Avenue, across from the Baptist Church, there is a single dwelling home. I can guarantee you there's 20 people living within that area, in the garage area and in that house. And, oh yeah, that's my cousin, that's my brother, that's my nephew. They're not all of the same. They're all of the same family, but they're not really connected. There's been numerous complaints about that. And Mr. McGarry can tell you that. What's the impact? The impact is once it's allowed, it spreads. This has gone from a single-family neighborhood, and I would say only 30% is now owner-occupied. It's terrible. It is absolutely terrible to know that you have no idea what is going to come out of the apartment next to you or what is going to come out of the house next to you. You have no idea. It just happens. It pops up and it happens. I had a vacation rental. I've since sold that home for the purpose that I did have a tax license. I did pay bed tax on it. But that home was not rented for less than 3 months, except for on 2 occasions when it was broken because of an emergencies of those people that came to stay. I was listed on vacation rentals. But I realized that what I was doing was causing more harm in the neighborhood than bringing good into the neighborhood. I sold that house. I had for 3 years paid taxes on it. This is a very big issue, and I do agree with Mr. Laufer and Mr. Burke. We need to get a hold on this, because if we don't define this any longer, every single neighborhood, not just on the mainland, but in the beach area, is going to start being rented out to whoever they want to rent it out to. And there has to be an ordinance, a guidance for every single house in the city of Vero Beach. It has to stop somewhere. It really has to stop somewhere. There is no security. We have no security when you're seeing people walking through the neighborhood. We had a big problem. It was doubled by the GO Line buses coming into our neighborhood, and since then they've gone. But just before I came to this meeting, I waited for a woman crossing the street, 18th Avenue and 23rd Street. I never, ever saw her before. And I waited, and I watched her walk to the Coral Apartments. This is happening every single day in Original Town, and it has to stop somewhere. And I'll take questions, but I just wanted everyone to know that there is security issues, and I am a property owner. What are my rights to all of these homes that are surrounding me that I have no say in because of the ordinance are so laxed? Thank you.
Thank you. Is there anybody else from the public who'd like to speak? If not, I'm closing the public hearing. Tim, you want to take a moment here? I think we're ready for discussion among the board. Any additional discussion among the board members?
I don't know what to say. We had a lot. I'm really at a loss of what to say. I mean, we made a proposal here. We've heard a lot of things. I'd like to hear from you all what you would at least give us some direction. Do you want to move forward on this or continue the hearing so the attorney and I can look at it a little more?
Did anything
Mr.
come
Chairman,
up?
I've been the one who was hoping this would be stronger than it is, but as I so succinctly said before, it's better than nothing, and I think we need to just move forward. And I'd make that, if you're ready for a motion, I'd make that in form of a motion.
I'm not quite ready for a motion yet, but
Okay.
Joe?
I feel that this is a good start, and we need a start. And I think that we cannot anticipate in any way all of the ultimate little refinements that might someday have to be made. But until we get the experience with it, we'll never know those things. So that's why I think we need to move forward on this.
Honey?
Yeah, I'm very much to keep our neighborhoods as stable as possible. One set of rules for everybody to live with is important. But did anything legally come up that kind of tweaks anything for you, Wayne?
Well, the only thing I might add to the discussion, and Tim, please correct me if I'm misinterpreting the ordinance, but as proposed, just for some clarification maybe, if a group of people, and one of the problems we were trying to address is what has been seen as problematic in other jurisdictions, and it kind of filtered down to us about what is a family. And because the way of our society has changed, the definition of family is not what it used to be 20 years ago when this was probably originally written, what we have. And so we try to get away from the blood relationships and marriage relationships and all those things. So basically, if a group of people is living together as a family unit, whether they're related by blood or marriage or not, if they're living together under the same roof, they're sharing the kitchen, they're sharing the bathrooms, they can certainly have their own bedroom, but if they're living together as one unit, we would consider them a family. That's not a problem. It's a single family residential district. Now, when it comes to the boarding house, what we're talking about, and maybe I should go to dwelling unit. The dwelling unit means that you have basically one unit that has all the amenities you need for living there, the kitchen, the living room, the bedrooms, the bathrooms. And then this family is sharing that dwelling unit. What happens is when you have the dwelling unit that you then start renting out rooms to other people, whether it's owner-occupied and you're going to rent out a bedroom or two, or it's occupied by a tenant in possession. In other words, they have possession of the property. If they then, of course, it would probably depend on if the owner gave permission to sublet, they could theoretically sublet a room under this ordinance. So you could have one main tenant, and that tenant could certainly sublet one room because the tenant in possession is really just stepping into the shoes of the owner. So you could theoretically still have, in the eyes of the owner, maybe only one tenant, but that tenant could possibly have a subtenant. And that would fit into, it'd be okay under this boarding house definition. But once that tenant rents out, or the owner is renting out the rooms separately, it's going to start turning into a boarding house, is the way I would think.
Yeah, I agree.
Interpreted.
I like the limitation on the one unit offered.
Yeah, I mean, as I said, we've looked at case law and opinions throughout the country, and they generally followed what we were just saying about that.
We've seen 1 and 2 rooms are permissible, but it's where do you want to draw the line? I mean, the council could see this and say we want to make it 2, we want to make it 1. We certainly probably wouldn't recommend 0, because you don't want to certainly you want to do the balancing of some rights here, obviously.
So that brings up a good question. You and I didn't talk about that. If it's a tenant possession, that means that person would have to be living there, right?
Oh, yeah.
Okay.
Well,
yeah. I just want to be sure that we're clear on our definition here, because I agree with what he's saying. Questions is our definition really address that very well. That's what I'm worried about.
I don't know if you're going to go from an owner to a tenant, and that tenant's just going to lease out the whole property. I mean, I suppose it's possible, but I don't think it's very likely.
No.
And I think so long as you have one main person or family, so to speak, that is got the possession of the property, however way they legally got possession, they could still rent out a room if they're in possession, whoever's in possession of the property.
But if they're not living there, could they rent it out to 2 different?
Well, like I said, legally in possession, then someone has to go from that tenant that's not living there to the person that's in possession. I think whoever's in possession of the property is more or less the person in the shoes of the owner that would normally be living there.
And I think that's what I want to be sure that the definition I don't know if the definition covers it that way.
Well, that's and Tim
that's
and I
what
talked
got
about
me,
this.
yeah.
We may need a little wordsmithing
That's
here.
what I'm saying, and
Yeah.
I like that.
Clarify it.
I agree totally what he's saying. I think the way it's written here, I want that to be clear. So because
Well, I don't know what a standard residential lease looks like because I've never been involved in one. But if I were to rent my home, I wouldn't allow sublets and sub-sublets.
Unless you wanted to do something that was contrary to the law, then you might. See, if it depends where you are on this. If you're trying to get more, then you would write your lease accordingly so that you can do it. In most of the leases that I have a few rental properties, and the properties that I rent out, my leases to do anything like that, they have to get permission of myself before they can do that.
And
in most cases, that would be the case.
That's common.
But the situation here that I'm worried about, I have two things. I think this is about as good as we can do right now, and therefore I'm in favor of it. I'm also had a little bit of the I don't want to go too far where I come into what Barry indicated, that we may be casting a large net and take out of the realm of possibilities the woman who wants to rent out to her, somebody to help her. And I think we've kept that. So it's a balancing act. We want to get it right. And I don't think we'll know whether we got it right or not until we implement it, and then we'll have to make revisions. And that's kind of where I'm suggesting we go. We implement it, and then with permission, we sit back. If you come back to us quickly with something that we did wrong on it, let's make it right, and so that we don't go too far or not far enough. But I don't think we can continue to let what we're calling nuisance homes out there in the neighborhood exist. I think we have to put something around that to try to stop that best we can. So now, if anybody have additional comments?
Would
Jim?
it be? No. What I was going to say, if you agree with the substance here to move this forward, you have any problem? The attorney and I will try to do a little more wordsmithing on this.
That's
thing
fine with me.
and move forward. But we're following the essence of what we talked about. Okay, I like the issue I just brought up.
Okay.
I think I just want to be sure everything's covered. He's got a couple other comments in there, but it would not change substantive.
Just wordsmithing.
Right. Yeah. Okay.
And this will
So
go
do you
direct-
want a resolution from us today to vote on, move this
And
forward?
Would you do that to support that with needed, with the necessary revisions?
Say that again, what you want exactly, so word it properly.
So moved.
Yeah.
So moved. Do you have that down, so moved there?
Second.
Is there a second on the so moved?
Second.
Yeah.
Okay.
Joe seconded it.
Okay.
I think we're motioning that we move forward with this. Thank you. And the vote is?
Take a vote.
All in favor?
All in favor,
Aye.
say aye.
Aye.
It's unanimous. Thank you.
Hey.
And just for your benefit, I would think we could get this to the council for first reading on August 20th, you think?
Yes.
Yeah.
Okay, August
So the
20th.
public
Okay.
can know.
Thank you.
Oh, thank you. That.
Does anybody here need a rest?
I'd like to have a little break.
Five
We have
minutes.
another
Could
hearing.
I just
but-
ask a question? Is that going to go, the plan development ordinance, will that go for a first reading on the 20th also?
Yes, it will.
Okay.
And with the board's permission, I'm going to suggest we have a 5-minute recess just for people that need to use restrooms. Okay, please keep it to 5 minutes. We'll be back at 3:30.
Take one from